Good afternoon, everybody. And welcome to docket number 260510, application of Connecticut Light and Power Company, DBA Eversource Energy, to amend its rate schedules. My name is Tom Wheel. I'm the chairman of the Public Utilities Regulatory Authority. I'm joined today by my colleagues, Vice Chairman David Arconti, Commissioners Jan Beecher, Holly Cheeseman, and Everett Smith. We do have an agenda in front of us today, but I figured what isn't on the agenda is everyone else introducing themselves. So I thought maybe we could start with that if people want to go around the room and just sort of say who you are and where you're from, maybe starting with the Attorney General's office.
Good morning, Chairman and Commissioners. Caroline McCormick on behalf of the Office of the Attorney General.
Good morning, Garrett Murray, Director of Revenue Requirements for Eversource Energy Services Company. Here on behalf of the Connecticut Light and Power Company.
Good morning, Brendan O'Brien, Vice President of Distribution Rates and Revenue Requirements for Eversource Energy, doing business as Connecticut Light and Power.
Good afternoon, Cassandra Dixon, Director of Regulatory Projects and Compliance at Eversource Energy, representing Connecticut Light and Power Company.
Good afternoon, Tiffany Tisler from the law firm of Keegan Werlin, here on behalf of Connecticut Light and Power.
Good afternoon, Commissioners. Vincent Pace on behalf of the applicant, Connecticut Light and Power Company.
And good afternoon, Cheryl Kimball from Keegan Werlin on behalf of Eversource Energy.
I'll continue the good afternoon. Brittany Wyman from the Office of Education Outreach and Enforcement.
Also, good afternoon. Tom Lopez on behalf of the Office of Education Outreach and Enforcement. Thank you.
Great to see everyone this afternoon. Just to mix it up a little, Claire Coleman, Consumer Counsel, Office of Consumer Counsel.
Hi, Kim White, Office of Consumer Counsel.
Thank you. Good to see everybody. I'm just going to make a couple of remarks. I'm going to try to make them brief. There has been already significant public interest, it seems, in this rate case filing that rate case has actually even been filed yet. But we commissioners have been discussing how we might be able to improve kind of public understanding and engagement in our proceedings. And one small way we've discussed is to sort of give an overview at the outset. This isn't really intended for the folks around this table who already know what we're doing here, but just for the public to kind of get a sense of where we are in this process. So as everyone in this room is aware, rate cases are particularly highly complicated and technical proceedings, both in terms of the substance and also the substance of what's being reviewed, but also the administrative procedure if you're not kind of accustomed to it. So again, I just wanted to kind of give a summary of where we are. So on May 20th, 2026, the company filed a notice of intent, which is basically just a letter announcing that the company has a plan to file an application for a rate increase. That's the very first step in a rate case. It's basically, again, just an announcement of the plan. Based on the company's notice of intent, we expect to see the actual rate case filing on or about July 14th, which is a little less than a month from now. Once that application is filed, a clock begins. So by statute, PURA has 350 calendar days after that point to conduct the actual rate case and eventually issue a final decision. Across that time, we have an entire proceeding that is sort of similar to a court trial process. It has a lot of steps. We'll have a chance to kind of get into I started out by kind of laying out every step of a rate case and realized that I'd be here for 4 hours. We'll have a chance to kind of address those at future points, including maybe during the public comment hearings once those are scheduled. But I just wanted to kind of convey to the public that this is a lengthy proceeding that hasn't actually even started yet. We are here today, though, for this preliminary conference to address questions raised by the company about filing the rate case application itself, and to discuss any other purely procedural issues that may come up in this pending case. For anyone who is following along with the docket, the company asked those procedural questions in a letter filed on May 5th, which was actually before the docket was opened. So you can find that letter in the docket system listed as correspondence, which is dated May 29th, 2026. Similarly, OCC and EOE also filed responsive letters to that letter on May 13th. Those were also uploaded to this docket on May 29th, if anyone wants to take a look at them. And OCC also filed motion number 3 in this docket on May 28th, requesting a technical meeting. So That's why we're here today, to address the issues raised in that motion as well as in the undocketed letters filed by all the parties. And that's kind of all I had. Again, I know everyone in this room already knew all of that, but I just kind of wanted to level set and sort of say that as an intro. So the first thing that we're going to do according to the agenda is, it's my understanding, Eversource has a presentation they'd like to share, so we can proceed with that.
Yes, and we want to thank the commissioners and also the docket participants for having this proceeding. We appreciate very much the chance to have this open and transparent discussion of the issues, to allow the commission to ask us questions and do our best to be responsive. I will mention we also do have here today other subject matter experts in the audience. So depending on the question, we will call them up to ensure we can be responsive to the questions that we get. And I want to mention one last point before I turn over to my clients, and that is, once we reach slide 5, there is an additional issue that I will add at that time once we get to slide 5. And it deals with the issue of, if you grant protected status and information, and we provide that to a party, do they intend to have their consultants use AI? And what guardrails will be around that process? So I'm just going to tee up that issue once we get to slide 5 and just raise our proposal for addressing that issue. So without further ado, I'll transfer it now to my client, Cassandra Dixon, and she can walk through the first slide. Thank you very much.
Thank you. And we can go to, right, thanks. So, thank you for having us here today. We're actually very appreciative of the opportunity to be able to have these collaborative discussions ahead of our rate case filing. As you mentioned, a rate case is a very complicated filing. This will be a very large case, and we're sensitive to that. And so there are very voluminous, documentations that we will be providing to support the costs in our filing. And so on May 5th, we thought it would be productive to follow up to a January session that PURA had facilitated to engage in procedural and administrative topics to better support filings. So on May 5th, we did file that letter as undocketed correspondence requesting 3 filing modifications for our upcoming rate case that we'll plan to file on July 14th. And so I'll walk through those 3 items now. So the first item is to eliminate the requirement to produce paper copies with the application, subject to production upon request. And so I will note that usually in the notices of proceeding, they will state how many copies are required for the rate case. In our recent Eversource case for Yankee Gas Company, in docket number 241201, there was a requirement to produce 15 hard copies of the application to PURA, 2 hard copies to OCC, and 3 hard copies to EOE. In the recent water company cases, there was a request to provide 10 hard copies to PURA and 2 to the OCC. And I will note that our notice of proceeding for this current case is silent on that issue. And so we would like to request to eliminate that requirement just due to environmental concerns, and let us focus on getting a quality filing electronically in the door. And we will absolutely support any requests for paper copies upon that request, and we'll provide them within a week turnaround. The second item is our submission of bulk exhibits. And so in this rate case filing, we are anticipating, we know there will be 4 components of the case that will be very voluminous. We have storm costs that we will be seeking prudency review of in this filing. We will be submitting 14 storms for review. We have 2 regulatory asset deferrals, which we will also be supporting with invoices. And so that's an environmental remediation deferral as well as a make-ready cost deferral. And then 4th, we will have capital project documentation associated with capital that was placed in service from 2017 through 2025. So 9 years of documentation, which makes up more than 1,800 projects. So our request in submitting these bulk exhibits is to provide them on a flash drive to whoever will need to receive the filing, as well as on SharePoint, with files organized individually into folders within folders. And we think this could be a more easier to review format, administratively efficient format. I think many of us were in our storm proceeding a few months ago where very large PDF files were crashing our computer in the hearing room during cross-examination. And so this would be a way to try to make that process smoother during hearings and during cross-examination so that there isn't awkward pauses and for us to be able to pull up those exhibits when they can't open. We also are requesting for those voluminous exhibits to provide those in confidential form only. We are estimating that the documentation associated with these 4 components of the case could reach up to 300,000 pages. That is an estimate just based on where we are today. We're still a month out from filing, so we're still compiling all of the documentation. But we are estimating it could reach that amount, and therefore we would follow PURA precedent in previous proceedings to submit that documentation as we have in similar proceedings like our Yankee Gas rate case and the storm proceeding, where that documentation was filed fully confidentially. And then we have a few slides later on to discuss our proposals and being able to provide public versions upon request or throughout the proceeding. And so I will mention, we filed this letter on May 5th. OCC and EOE filed a reply on May 13th. And just in the spirit of collaboration, we did facilitate a meeting on May 28th with the OCC and EOE to walk through our filing modification requests. We realize sometimes, words on paper do not come across as we intend. And so what we did at that meeting is share screen the files and gathered some feedback for how EOE and OCC would like to review the files in a manner that would be as easily as possible for them. I do want to make clear that we are not trying to withhold any information in this case. In fact, it is the opposite. We're trying to make it as easy as possible to review the information in this case. We know this is a very important case, and so we thought engaging in those discussions, and certainly today, is a very productive way to be able to gain alignment in how we file our documentation so that when we're in the case, we are past any disputes and we can focus on the case. So turning to the next slide, I will walk through our proposal for filing invoices. And so what I did with the next 2 slides is go through 2 examples. So this example is a storm invoice exhibit with the associated invoices to support it. But environmental and make ready would follow the same structure. And so the top half of that slide may look familiar to most folks. That is the same format that we filed in the storm cost proceeding as far as the indexing of costs go for invoice payments related to each storm. This is illustrative. We're still finalizing our case, so exhibit numbers are not yet final. But for purposes of this slide, let's call that Exhibit CLMP 2. And so Exhibit CLMP 2 would be that storm cost listing for that particular storm. Now, if you go to the bottom left of that slide, that would be our proposal, is to file individual invoice copies stored in a folder. That folder name would be Exhibit CLMP 2A. And then all of our invoices would follow, saved sequentially, following the exact indexing of the cost exhibit above, so that everything is in order. When we met with OCC and EOE on May 28th, they did share with us that they would prefer consolidated PDFs, which is no problem at all. We would just propose that we would break those PDFs into file sizes that are manageable to open, so that they are not too large when we're in the hearing room to open. So this particular storm has 500 invoices that support it. When we take a look at, the size of those invoices and what's contained in it, it would require a 20-part PDF. That is, each PDF would be under 40 MBs. And so we would just like feedback as far as like what is the easiest way to review. We realize we met with EOE and OCC, but certainly Pura staff will be reviewing this filing and other stakeholders. And so we just want to be able to make it as easy as possible going in the door. Going to the next slide, I'll discuss our proposal for the capital project documentation. And so as I mentioned at the outset, we will have, I think it's upwards of 1,800 capital projects now at this time, from 2017 through 2025. And so at the top left corner of this slide, this walks through an illustrative example of the project documentation matrix, which will be providing all projects placed in service with a bunch of different details such as costs, variance analyses, descriptions, et cetera. I've only showcased a few columns here. But the way we would file the documentation supporting that, in the top, in the bottom section is where we walk through our proposal for providing that documentation. And so if the top exhibit, let's just call it CLMP Additions 4, say that's the name of the exhibit, we would then have CLMP Addition 6 supporting all of the projects in that exhibit, which is the project documentation. And so our proposal is to provide within the folder named CLMP Addition 6, 1,800 project folders, which within each project folder would contain each project's associated documentation. And so this would also be indexed according to that index above. And so the folder names are in sequential order as associated with the indexing above so that it's as easy as possible to follow. I will mention, and this is mentioned on the slide, this is the way we file our project documentation in our Massachusetts jurisdiction. In the Yankee Gas rate case, there was testimony filed by the OCC in that case that pointed to our documentation that we have filed in Massachusetts and endorsed the format of that documentation. And so that is essentially what we are doing here in this case, is filing it in the same way that we file it in Massachusetts. Within each folder for each project, on the bottom right shows what is the documentation in each folder. It's all going to be labeled the exact same way so that there is no confusion as far as whoever is reviewing the documentation, what is being presented there. And so we will have closing reports, which essentially includes all of the costs that make up each project, a PAF, which is a project authorization form, and all the approvals associated with the project. On the top right-hand corner is just showcasing if we were to combine all of these projects, it would be a little messier than the invoice route just because of the volume. And so 1,800 projects, we're estimating it would probably be more than a 60-part PDF. So it could potentially be Exhibit CLMP, 6A through 6BF. We're still finalizing all of that, which we think could get confusing with a page numbering index. If we're being cross-examined or during discovery or whatnot, it may be easier to just open up a folder and reference it that way. So that is our proposal for the project documentation. Keep going unless there are any questions on the format.
Thank you. Just quickly, you said with regard to the prior proposal that you'd had feedback from OCC and EOE. Did you have similar feedback with regard to the treatment of the capital projects? Was that also included in the conversation?
Yeah, so I don't want to speak for the OCC or
you
EOE.
obviously, yeah, but I was just curious because you made a point of mentioning that in the prior slide, and I
Yeah.
wasn't sure what the outcome was of the conversations, but I presume we'll find out before too long. Thank you. Thank you, Mr. Chair.
I had a question that might depend on the extent to which SharePoint is used or that format, but I'm wondering if your index file will be hyperlinked or even within files, will they hyperlink since we've got a lot of interrelated evidence that will, or record that will probably be relevant? In other words, yeah, will you be able to, move through that index that way? Have you thought about that?
We have not thought about that, but I don't think there's an issue to explore it that way. We probably could hyperlink it if it would be easiest.
Okay, thank you.
I think the plan was to kind of get through the presentation and then move on to the discussion part. So, I mean, I think it's fine if people have questions, but
I can
if
keep
you want
going.
to, if you want to move
Yeah,
on.
yeah.
Sure.
Okay, so then moving on to the protective treatment of the confidential exhibits. And so we do understand there are sensitivities here in all of the responses back to our letter. There are concerns with producing this information fully confidentially, which we understand. And so what we want to really express through this slide is, and I will hand it over to, Mr. Pace on slide 5 to talk through the legality of what can be confidential versus not. But we do have proposals to get us around in this case to provide public versions of the documents. And so during discovery, we plan to proactively, if there is any question on any invoice or on any project, we plan to proactively, as part of that response, provide the documentation associated with that invoice or project in redacted form. We also, as I mentioned, I skipped the first bullet, but as I mentioned, the master indexing was on the previous slides. That master index will be fully public on Pura's website, which will list all of the costs. And so if there are any requests for any of those costs, we will certainly provide those in redacted form. Also, we did understand at the meeting that we did have with EOE and OCC that there could be concerns around, well, if everything is confidential, what do we do at the hearing? How do we feel comfortable that questions could be asked at the hearing, knowing that there is some information in those documents that is public? And so we are happy to work through that with, any appropriate guardrails. In the storm proceeding that I mentioned before, the documents that we filed were fully confidentially, and they were cross-examined throughout the entirety of the hearing. And we just noted during, the line of questioning whether or not the documentation on that specific page was confidential versus not, and if the questioning could proceed. And so we'd be happy to do the same here. And then lastly, we are more than happy to assist in responding to any FOIA requests. We are certainly not intending on putting the burden on any other party. We would respond to those requests, and we would redact upon request if those requests were to come in. And so then I'll turn to slide 5, and just before I hand it over to Mr. Pace, I do just want to mention we are just trying to follow, Pura precedent on these large, high volume, confidential files. And so I will just point to in our last Eversource rate case, so our Yankee Gas rate case and docket number 24-1201. I'll point to motion number 59, which Pura granted our request to publicly, to not require us to publicly file bulk confidential documents, where we argued redactions to 33,000 pages of invoices would cost $97,000, and no feasible method for redactions other than manual review existed. I will also point to docket number 24-0330, which was the storm proceeding most recently, motion number 17. And that is where Pura protected confidential only versions of vendor invoices in their entirety to protect the interest of customers in maintaining competitive pricing. We also reached out to third-party vendors in that case as well. We provided 150,000 pages of documentation associated with that motion. And the quotes that we had received at the time ranged anywhere from $300,000 to $400,000 to redact those documents, which no automation existed at the time. It would have been a manual review, and we are just concerned with that manual review happening that anything could be missed. And I will hand it over to Mr. Pace to just talk through our concerns on the security issues there.
Thank you again for the opportunity to add some thoughts on this slide. I think what's important just to emphasize again would be on July 14th, when the filing is made, immediately all 5 commissioners, the PURA staff, the Consumer Counsel, DEEP, and the AG will have immediate access to all this confidential information. So they will have full access to be able to do their respective jobs. So at least from my perspective, the open issue being presented to you for consideration is there an obligation for us to post on your website redacted versions of that? Does the law require that? And also, is that feasible? As to the first piece, when I looked at our Freedom of Information Act, and in particular, General Statute 1-2110, I see no requirement that says if the agency concludes a document contains confidential data, that we must provide a public redacted version of that. There may be arguments that that's an equitable thing to do, but actually the statute doesn't specifically say that. It says if we demonstrate that we meet the exemption, then the document at that point is exempt from public disclosure. Now, we've done that as a matter of practice and convenience because it's been feasible in prior situations. When you have 300,000 bulk documents, it raises the issue of feasibility, and I thought that was helpful context to have. Ms. Dixon also pointed out there are prior decisions from this agency that concluded that we should protect this type of information, and you have protected it on a confidential basis. And the last point I want to add is one I mentioned when we opened our presentation, which was in preparation for today's proceeding, we had a conversation with our IT security professionals, and they said, have we talked about and do we have a process in place whereby once OCC, AG, DEEP, and others actually receive the confidential information, if one of their consultants wants to run all that data through AI, what are the protocols? What are the safeguards that we have in place? Now, to be clear, we're not saying they can't use AI. What we're saying is if a party wants to use AI, how do we make sure nothing bad or unintended happens with that? So in talking to our IT professionals, their recommendation was, could a party provide us with notice that they plan to use AI and then just be able to answer some basic questions about what AI model do you plan to use and what are the safeguards in place for that particular AI model? We're not trying to do discovery for them. We're trying to, get into their preparation for the case. But the concern I think we all have with AI is there's unintended consequences. And not all AI models are the same. And so the concern would be if they intend to do so, provide us with the notice and answer some basic questions about the safeguards their models have in place. We think that's a very reasonable approach. It's an emerging issue, and we want to just make sure that we handle it in a way that's responsible and we safeguard this important information. So I have nothing to add to this slide unless you have any questions, and if not, we'll move on to slide 6 and hand that over to Mr. O'Brien.
Thank you, Attorney Pace. And just wanted to reiterate the comments of my colleagues, just really appreciate the opportunity to appear before the authority today and with all the stakeholders to talk through these issues. And Chairman, as you indicated and as outlined in the May 20th letter of intent that we are intending, and as we've discussed here, and planning to file our rate case on or around July 14th. And following the statute, that would put a decision date, around the time of June 29th of 2027 to fulfill the 350-day statutory requirement. Given some recent modifications to legislation last summer, the company is constrained to a relatively tight window in order to maintain some certainty regarding the implementation date of our first rate case in close to a decade. And additionally, as we have previously acknowledged, I believe in the recent RAM proceeding, the company's original plan for our letter of intent and ultimately our rate case was to file that in early May with planning to file that rate case at some point in early June for rates to then take effect around June 1st of 2026. However, Connecticut Water did file a recent rate case application on May 11th in docket number 260315. And in order to respond to that, the company did need to modify our plan in order to maintain some certainty regarding the actual date of rates becoming effective, given to recent changes to the statute. And just to kind of lay that out from a timeline perspective, in order to ensure that we are filing our application more than 60 days after that application from Connecticut Water. The earliest date we could file that would be July 11th of 2026, which is a Saturday. And the company's plan is to obviously, as we indicate here on the slide, file our application on July 14th, just 3 days later. And just to highlight too, just even filing that a few days earlier prior to July 11th would subject the company to a significant amount of uncertainty regarding the implementation and the effective date of our rates, as the statute now allows for a delay of up to 90 days due to the recent implementation through SB4 just last summer. So we obviously appreciate some of the timeline constraints and items that was outlined in the notice of procedural conference here, and have certainly tried to do our best to lay out some options. If we could transition to the last slide here on slide 7. To accommodate those concerns. And, really from our perspective, I think that broke down into two options. The first would be to have the rates take effect on July 1st of 2027, and to outline an option for those rates to be implemented at a later date to take effect on August 1st and allow any necessary time to go through any compliance or procedural orders after the final decision date or the final decision is issued in late June. So here we've outlined two options. The first, which may not be the more preferred approach and obviously has more of a direct bill impact, but would be to have rates take effect on August 1st, and for the first year have that be over an effective period of 11 months. But obviously that does have a larger bill impact for that first year of implementation. The other option that we lay out here in option 1B is to take a similar approach to what was just recently taken in the Yankee rate case, as well as I believe some historical settlements that the company has been engaged with as well, to have rates take effect on July 1st of 2027 in accordance with the statute, have those rates then be implemented August 1st of 2027, and then any associated under recovery for that process would be caught in the company's decoupling mechanism, which would be filed in the subsequent RAM proceeding, and then any associated under recovery for that one individual month would be amortized and collected over a subsequent 12-month period, mitigating some of the bill impacts of that specific scenario. The second option that the company also outlined was just, similar to what we, I think, all have recently discussed in a similar procedural conference in the storms docket just a few months ago, would be for the parties to convene and certainly look at the schedule to see if there is any accommodations that could be made amongst all the parties to identify a schedule that could potentially have a final decision date issued prior to that June 29th, 2027 date, and would allow for some time for all the parties to obviously take that final decision, go through that, and work through all the necessary compliance filings, getting rates effective, and planning to get those implemented in the company's systems for effect on July 1st. And certainly those could be interchangeable as well if we wanted to look at the schedule and also pursue something like decoupling like we have in the past. That's certainly something that the company would certainly consider. So with that, I think that completes our formal remarks and process. But again, just wanted to reiterate our appreciation for the opportunity to be here today and talk about this issue, and happy to take any questions on the presentation. Thank you.
Thank you. So my thought was, I think I just have a tendency to want to draw things out and make them as long-winded as possible. My thought was that we could go through the kind of 4 issues one by one and sort of circle around and have a chance for everyone to kind of respond, and the company can respond to the responses, and the commissioners could jump in. So if that sounds okay with everyone, we can start with, I think, is probably the easiest issue, which is paper copies of the application. OCC, do you want to weigh in at all on that request, the waiver of filing paper copies?
Thank you, Chair Wheel, and thank you to Eversource for the presentation. That is a very easy one. We have no objection to waiving the paper filing requirement.
Okay. EOE?
Nothing to add.
Okay. And I think I do want to acknowledge, we also, we have DEEP as a statutory party, and we also, I forgot. I was going to say, we also allowed motions to intervene from the AG's office and also CIEC, but AG's office, do you have any?
Nothing to add. Thank you.
Okay. Okay. I mean, the only thing I would note is, I mean, I personally also am not I don't read paper anymore. So personally, I'm fine with it. We do have, I'm wondering if maybe though, for the best way to deal with this might be to include in the application a standard waiver of requirements. Our SFRs, which are from 1990, whatever, I think still do actually require paper applications. Our regs might actually offhand list out, you know, the origin of the language that used to be in the notice of proceedings might technically still apply according to our regulations. So it might be cleanest just to file one of those standard waiver. I think we'd be fine with just an overall waiver of paper filing requirements. I don't think the company needs to chase down where they might exist.
We'd be happy to do that, and we can easily do that. Thank you.
Okay. Any other commissioners want to meet? Okay. The next is the bulk documentation proposal, including the capital project documentation proposal. OCC, did you want to weigh in on that?
Thank you. I believe we also have no objection to the bulk filing so long as it's done publicly, which I think is the issue we'll get to in the next round.
Yeah, the third thing.
Attorney White may have a caveat that I'm not.
Yeah, we are going to, for clarity, talk about the redactions issue separately as the third thing too. So this is just the proposal of the, I think as I understand the proposal, is essentially, can you file via SharePoint instead of direct upload via the Lotus system? That was the.
Yes, we're fine using SharePoint or flash drives. Anything else you'd like to add?
Yeah, this probably falls into the bulk filing category, but and this was represented when we talked about the way they structured it and having each invoice be individual PDF. We were not in favor of that, and I think they reflected that and said that they would address that concern.
Okay.
I respond.
Sure.
Yes, I think that's totally fine for the invoices. It would be the project documentation that would be difficult to combine. So as long as we're okay with filing all of the invoices in PDFs, combined PDFs for the project documentation, we would still propose to file it in folders, if that is okay.
Yeah, so there would be a folder for each project, so we wouldn't
Yep.
have to, okay, that's great.
Yep, thanks.
Okay, EOE, any?
No, we have no issue with their proposal on that piece.
Okay. And AG's office.
Yep, same with us. Nothing to add there. Thank you.
Okay, thanks. My only question was, I just wanted to kind of say out loud, a shout out to docket control. So when the stuff gets filed electronically, there is a human being who works for us who has to nonetheless do the horrible task that you understandably want to avoid of putting this all up onto Lotus so that it is publicly available. And I know that I also say, like, I docket control is great, and they are great at facilitating these sorts of things. But I guess my concern is, I just want to make sure that this isn't applicable to every kind of filing. Like, I think we just need to restrict this to things that are in and of themselves bulky and impossible to kind of parse out into individual filings, if that makes sense. I just am sensitive to the idea. I'm looking at Laura Lupoli too, who might also be burdened with some of this. I just don't want to transition to a place where essentially this just becomes Pura's job to have to put all this into Lotus on behalf of parties. So I think I understand the request to be that for things like you're trying to file as part of your application, all documentation of all the plant additions sought for recognition and rate base. I get that in and of itself is just a giant chunk of data that sort of needs to be in one place. But can we kind of consider kind of restricting this to just that kind of filing? That's something that's just too big to kind of be able to put in Lotus?
Yes, absolutely. It really would be just this circumstance, yeah.
Okay. Ms. Lupoli, you cool? You're okay. Thank you. We always worry about whether Laura's happy. So. Okay. The other thing this is the closest related area that I wanted to raised this. I just asked this in another similar proceeding, another rate case. Can I request no Word files unless it's necessary for a Word file to be a Word file for whatever reason? If Word files can be PDFs, and transparently, the reason for that is that when a Word file is posted on the public-facing version of Lotus, and when we're following along in a hearing or something, I literally have to like download the file to my computer, open it up in Word, and by the time I'm on that, we're onto like a different subject. Whereas a PDF, you can just instantly open and it opens in the browser. So that's my rationale. And I do know, I think in a Pura of your required Word files, so I know that I'm kind of like changing the rules here, but is there any objection to the company on that?
I'll look to my expert, Ms. Dixon, if she could respond. Thank
We
you.
hate Word files, so we will not file any Word files.
Great. Anything else from the? Okay. Now on to the redaction issue. We did see the letters from OCC and EOE and the motion. I think this seems to be the area of where we're maybe not all on the same page, just recognizing that. So OCC, do you want to be heard on the redaction question?
Sure, I'll start and let Attorney White supplement. As the authority acknowledged and Eversource acknowledged, this is an incredibly important proceeding for a significant portion of the Connecticut public. We believe that transparency and public access to information is critical throughout this proceeding. I understand the concepts articulated by Attorney Pace. I think what was not addressed is the fact that Pura is a quasi-judicial body. And I think Chair Wheel, this morning, you said something about this being a court-like trial process. And if you look at the Connecticut practice book, and for the same public policy reasons, right, when you go to court, briefs, evidence, everything's filed publicly because of the same concerns. And we think that there should continue to be a presumption that documents are filed with Pura, just like they are with courts, in a publicly accessible format. I appreciate the company's suggestions of alternatives. Unfortunately, we don't think that any of them meet the mark in terms of transparency or feasibility. We do have a concern that having to sort through a bulk filing that has some confidential and some non-confidential information in it puts a huge burden on us. We're already significantly disadvantaged in resources, and to try to figure out what we can talk about in a public hearing and not is incredibly challenging. And then it also puts an enormous burden on Pura if it does get a FOIA, which, given the significantly public nature of this rate application and the attention that it's getting and likely to get, is highly likely. I think we should all think about solutions that anticipate FOIAs if there were mass bulk confidential filings, and that would require Pura then to work on the back end with the company to figure out what portion of that document should be redacted. And I think that's a difficult thing to ask the authority to do as well. Attorney White, is there anything I missed?
So I'm going to turn this a little bit. So first off, obviously, I echo everything that the Consumer Council said, and I believe that the public knowledge of this is the foremost issue. From my perspective, from like a practicing attorney issue, though, I see several practical issues with what they said. They're talking about the way it is described. We would have to guess a little bit as to what is confidential and what's not. We're going to be asking, obviously, several interrogatories in this. We're going to have to guess in the interrogatories as to what's confidential and what's not. Erring on the side of confidential means the burden is placed on us to redact interrogatories that we might not have to redact otherwise. Once again, from a practical aspect in a hearing, I understand what they're saying is, oh, we'll tell you then. Well, that's a little late in the game to find that out, quite frankly, especially for something, the volume that we're talking about here, for us to figure it out in that regard. just from a practical aspect of a practicing attorney and staff and everyone that is going to be, dealing with these files, I think that's going to get very unwieldy very quickly.
EOE?
I don't know. Thank you. So I agree with all of those pieces. I also, and I also appreciate the company's position of, some of the practical nature and problems, and some of the solutions that they presented. I also agree they don't fully miss the mark. I certainly see concern with, the company offering to assist Pura in FOIA response if it was requested. I mean, even just a practical question, I think a lot of, just in our experience in the storm docket, right? The majority of some of those, and I understand the timeline was tighter. The timeline isn't so tight here. They've also had years, I guess, to think about this filing. It's been a decade since their last rate case. And so I think, just from a practical perspective, most of these documents are not, in fact, confidential at all. Most of the material on any given page is not, right? Particularly like the invoices. A few of the numbers might be confidential, but all the hours worked, for if we're talking about storms and they're filing 14 storms here, right? Travel time, standby time, all those hours, none of that's none of that is confidential. So I think, I could just presume and ask interrogatories and not redact them because I know they're not confidential. But I do think it speaks to the larger point of someone requests, what's to stop anyone from asking for all these documents, and they should be available to the public anyway. So, I see that the company. I did like it. I think it was on slide. Was it slide? Maybe 5 or 6, but of course I went to screensaver, but ultimately it was something like, appropriately requested FOIA requests, and then they'll assist with those. Well, I mean, Pura has the burden of making that determination, not the company. And we can't get into, a back and forth of, well, they disagree with what Pura is deciding on a FOIA request. So I think that, they're kind of shifting the burden there, and really right, like, this is a public proceeding. So yeah, to assist in responding to any valid and properly limited FOIA requests. So I don't know what properly limited is. Obviously, right, like, has to be a valid FOIA request, but that burden isn't very high either. So just interested in maybe even the company's thoughts on that. But I think it's also something for the authority to consider as well. That's all. That's it.
If I could just add one thing to bring it back from the procedure of it, as Director Lopez noted, it has been almost 10 years since their last rate case, since Eversource's last rate case. And that was a business decision for one reason or another. It's been 10 years for a multitude of reasons. And I don't believe the general public should feel the consequence of those business decisions.
AG's office?
Thank you, Chairman. We second the OCC and EOE's points, and we share the same concerns about feasibility, practicality, and really importantly, transparency to the public in this, as well as the inappropriate burden shifting to the parties, interveners, and the authority. And I'd like to second Attorney Wyman's comments about this in addition to everything else. the public shouldn't be punished for Eversource's business decision here.
Thanks. I'll give that company an opportunity to respond. I did just want to toss in some comments of my own, and these are just my own reaction. I did say, well, the authority will issue some formal guidance later. I just want to say I understand the problem, like the practical problem that the company has here and the enormous amount of work it would be to redact all of this stuff. I totally get that. But I have to say I have this exact same thought about FOIA. I also want to say, I think it extends to, we have 3 state agencies here who are going to have these documents. It wouldn't just be us. It would be OCC, it would be the Attorney General's office, potentially DEEP also if they had access to the unredacted files. So it isn't even, the question of if any of us are FOIA'd, what happens is an interesting one. I did see the companies offered to assist. I don't know, that makes me nervous legally. Like, it's our liability. It's us who's answerable at a FOIC proceeding as to like whether we appropriately redacted or the information we provided. I don't really know how that. I don't know that we can show up at FOIC and say, oh well, Eversource helped us with this. Like, I don't know if that solves that problem. And I think honestly, like just being completely honest, FOIA exemptions are permissive. I think the easiest thing for us to do would just be to hand over the entirely unredacted documents if we got FOIA, to just say, here it all is, like, here's what we have, as opposed to kind of, subject ourselves to the liability of having to be answerable to this stuff at the Freedom of Information Commission. I also did just want to say that I'm glad people are referencing the storm proceeding. There was that kind of large document there that we sort of had the technical problem on our side of being able to open, which the company has already referenced. I got to say, though, it did bother me in that proceeding. We had maybe like an hour of cross on this document. It bothered me that like we're live streaming this and no one who's watching has any idea what anyone's talking about. Like that was an issue and I think we do have a responsibility to the public to be doing our best to kind of make sure people are capable of following along sort of what's happening in our proceedings. So my personal reaction is it does trouble me the notion that we'd be potentially having lots of cross-examination questions in open proceedings where people who do have access to the documents are asking questions about them and no one else has any clue like what's being discussed. But again, I say all that with the acknowledgement that I understand the reason the company's making this request. Any other commissioners have anything to add?
I appreciate the discussion. I mean, these are fundamental issues about open government and conducting the public's business in public. So I kind of concur with the chairman's remarks just now. But I am wondering from a practical standpoint, there are subsets of information, including, for example, information that involves personal customer data, proprietary data, maybe data related to security that are recognized by law or perhaps regulation. So I'm wondering if parties could give some consideration to that, whether more narrowly, you could agree on that where by practice we wouldn't want to disclose someone's information, and maybe you could have a conversation about facilitating filing that is consistent with those principles and practices. But I'm just throwing that out there as something to think about, but while still recognizing the very real concerns I think that everyone has. Thank you.
Does the company want to respond?
I would, and thank you very much for the helpful feedback. I appreciate hearing the concerns that are raised by the other parties, and I'll endeavor to try and respond to the feedback that I heard. What we'd like you to please consider when you deliberate over the issues presented to you today would be the following key points. The first would be, in the other jurisdictions we work in, we recognize you're not bound, of course, by Massachusetts or New Hampshire law, but the public utility commissions in those jurisdictions do agree with the approach we're recommending here. And those states do have freedom of information laws. They do have consumer advocates who raise the concerns you heard today, but on balance, after weighing the respective arguments, those jurisdictions conclude that there is an important interest in protecting this information, and the parties still can get their respective jobs done in an open, transparent rate-setting process. The second point I'd like you to please consider, Attorney White raised a point where she said, from a cross-examiner's perspective, it's tough to figure out what exactly is confidential. And I appreciate her point, because as a cross-examiner, she wants to be able to know exactly what is or is not off limits. We think a helpful way to respond to her point would be the motion for protective order will specifically identify what information on those pages will be protected. So you can look at the motion, it'll say you can't talk about someone's personal cell phone number or their home address, or you can't disclose a bank account number or vendor pricing information. And Chairman Wheel talked about the fact that we did encounter the issue recently in the CLMP storm cost recovery docket, which was docket 25-1213. I think one benefit there would be, in that proceeding, we provided documentation containing confidential vendor pricing information from 2018 through 2023. And we were able to get through cross-examination, and the parties were able to make their points. And I think we have a history of being able to do that. If somebody did find it to be difficult or challenging, one workaround that we offered would be, we've not said that we would never provide redacted copies of this information. What we said was, out of the universe of 300,000 documents, if a party during discovery says, I really have some interest, for example, in vendor A's invoices, and I want to ask you some more detailed questions, then we know they have a focus on that. In response to their interrogatory, we will provide a redacted copy of vendor A's invoices, because we know they have an interest in that. And therefore, when we get into the hearing room and they want to ask more questions, that'll then be in the public domain. I think the key question you're really being asked to consider is, does FOIA require you on day one of the rate filing to have in advance posted on your webpage redacted copies of all of this information? And I would respectfully submit, I've read the statute. I've looked at General Statute 1-2110 subsection A, and my reading of that says, if we demonstrate that the information is protected, then the entire document is exempt. There's no statutory requirement for the agency to then order a redacted copy. I understand the public policy reasons that Commissioner Beecher and Chairman Wheel identified, but I'm just pointing out the statute doesn't actually direct that once you find we're exempt, that we have to provide a redaction. Nor has any party, at least to date, provided a court case that says you must file a redacted copy when an executive branch agency concludes you've met an exemption from public disclosure. Some other points I'd like you to please consider would be, Ms. Dixon did point out that we do have some prior period decisions where you've actually agreed with this approach. So this is not something that we're asking for that's unusual or different. She cited to a number of situations, and I can provide other dockets where this approach has been agreed to here in Connecticut. We'd also like you to consider that not all the information we provided is the same. What do I mean by that? Ms. Dixon said there's two categories of information. The first of which is information about our infrastructure projects. So think about that. We're providing 9 years of information about all of our infrastructure projects. One concern I've not heard people talk about is, if we're ordered to put on your website 9 years of information about our capital projects, could somebody from China or Iran or someone else put that into an AI model? What do they learn about our system? So I'm not trying to scare people. What I'm saying is we have to be realistic in terms of how could a bad actor take this information and manipulate it in a way that we're concerned about. No one's talked about that, but that's a factor I'd like you to think about as an agency as you deliberate and look at our request for that important subset of this information. In looking at the last points that I want to make, I just want to go back to the fact that we understand that the public has a very strong interest in this rate case proceeding. And of course, their interests are being evaluated and protected by the Consumer Council, the Attorney General, and other participants. and you as commissioners take their interest into consideration and you balance that with the public service company's interests. And I just want to go back to the issue of, we have an assumption here that a member of the public has actually filed a request and wants the information. That's speculation. There's been no such request that I can recall in prior rate cases. And so we have an unsupported assumption. And what we have said is, if some member of the public does come and say, we want to look at this information, we've offered that we will support the authority and we would promptly provide redacted copies. When I look at the law, what it says in General Statute 1-2110A is that if we fail to meet an exemption, and I've said we've met the exemption, but if we fail to meet it, a public document has to be produced promptly. And what I'd like to point out is our research of the case law says promptly doesn't mean immediately. What our research demonstrates is that courts have said, for example, in 222 Connecticut Appellate 17 at pages 50 to 51 at footnote 10, that what promptly means depends on the individual facts and circumstances. So that if a member of the public were to contact you and say, I want 300,000 pieces of information, the statute doesn't say you get it the next day. The statute says you receive it promptly, which means reasonable based on the scope, based on the facts and circumstances. But again, I go back to the fact that in particular with the infrastructure information, we meet the exemption. And the exemption that we meet, there's actually two subsections that we meet that protect that information. First is General Statute 1-2110B, subsection 19. It says, records will be protected where there's reasonable grounds to believe disclosure may result in a safety risk to any facility or of any fixture or appurtenance and equipment attached thereto. And that clearly says that it applies to public service companies. And then also subsection 20, which is records of standards, procedures, processes, softwares, and codes not otherwise available to the public, the disclosure of which would compromise the security or integrity of an information technology system. So we think that we've proposed, I think, a very nuanced and reasonable response to the concerns that we're hearing. Again, we recognize that the important public interest, but we think that has to be balanced with the important safety and security and grid protection concerns that we've raised. And I hope that in my comments, I've walked through the fact that this does not unreasonably impair the ability of parties to do their job and to cross-examine our witnesses. I'm happy to take any additional questions if you have those. I think Ms. Kimball maybe has one other point she'd like to make.
I just had on to Mr. Pace's two things that we didn't mention yet. In Massachusetts and New Hampshire, we have protection of these things for the reasons that Mr. Pace just critical energy infrastructure and competitive sensitive commercial terms. If Connecticut lets this information go public, it destroys the confidentiality in Mass and New Hampshire, because one of the standards we have to meet there is that it's not publicly available other places. So then it will cause us to lose the confidential treatment in those other states. We have all the same concerns from the advocates there, from the AG's office, from DOER, which is their energy office. But we work through it together by having the parties identify, for instance, the projects that they're interested in looking at. All we're saying is that, and what the department and what the New Hampshire PUC recognizes is, you can't redact 300,000 pages reliably. And so there is a process where we go through where we identify, as long as somebody is identifying to us out of those 300,000 pages what they want to look at, ask questions about, we can produce redacted. We're not saying we won't do redacted. We're just saying it's not really physically possible to do it. Even if we send it out to a vendor, and we've spent a lot of time looking at this, you can't be sure that if they're using some sort of machine or a bot, like that it's even reliable. So you still have to kind of review it with a human. The other second thing, so that does change things in Massachusetts and New Hampshire for us. The other thing which has just only come up in the past couple of weeks, is the company is being approached by vendors, and we're happy to put in an affidavit if this would help, But vendors are starting to come to the company where they're selling aggregated data that they've pulled off of PUCs across the country for utilities, and they're offering to sell these databases to the company in with like analysis of their confidential, of things that they found on websites about other utilities. So I think the technology is running very fast right now. And so to put, even if it was just 1 year or 2 years or 3 years, you're putting an aggregate of information out that somebody can pick up and make some use out of. Like, I don't even know that we completely understand this. And I'm happy to we can put in an affidavit if you'd like from our engineering and IT department of the risk that that's creating. So I think that legally what's happening is there are exemptions that apply. Once the document is exempted, it is no longer a public record. That means when you get a FOIA, it's not a public record. In the interest of trying to balance the public disclosure against the public interest in preserving the confidentiality for customers, we're offering up a redaction process. But legally, once it fits under the exemption, it's no longer a public record. Public records are things that do not fall under the exemption. So lots of issues to consider. We will do anything reasonably possible to make this work and to make it easy and to try to relieve some of the burden that we know it does place on the other agencies. And it could just be as simple as giving us a list once a week of project numbers, any project numbers they want to give us. If it's 100, give us the project numbers. We'll redact those pages. I think that's it.
I just did want to respond to something that Chairman Wheel said as well about the concern that other public agencies like OCC and the Attorney General Office would also have these confidential filings, and then they could be subject to FOIA requests themselves. Just to go back, because it's difficult in the midst of a rate case to go back to the very beginning and remember how the process works, but in my experience in these rate cases, the first time that we file a motion for protective treatment, we also file a non-disclosure and confidentiality agreement that then OCC and Office of Attorney General and any other state agency would have to sign before they receive the confidential filings. And then that agreement applies throughout the case for any confidential filings, and essentially, it binds those agencies under the terms and conditions to follow PURA's rulings as to the confidentiality status of these materials. So I just wanted to make that clarification that if PURA decided one way or another, that the other state agencies would essentially be bound by PURA's ruling and would not have to make these determinations on their own.
Thanks. I think Commissioner Cheeseman's ahead of me in line.
I will always defer to the chair, but I acknowledge your graciousness. So my question to the company is this information so intertwined, woven into everything that you're going to present that it's impossible to segregate out sections that you feel would be specifically warranted for protective status? I mean, is it every single one of the 300,000 pages has something on it that you don't want someone else to know? Or is there some way to create a subset about which we would have this conversation?
So that is such a good question and a key question. And I'm sure that Mr. Lopez, I can see him out of the corner of my eye. So I'm not going to cross him. But no, not every page is going to meet the legal standard that Mr. Pace laid out. But the document meets the standard because the document contains this information. And the problem is the redaction process. So if we took the project documentation for 1,800 projects, there could be as many, 60, 100 pages or more for each project, correct?
Yep, correct.
And so the process it's the part about going through in every single page and trying to extract that. It's difficult to do it by machine. because there's all different formats. If we just had 300,000 pages in a similar format, some kind of template, then you could search and you could potentially weed out. Could we start a process today that goes through some of the equipment documentation to look for pages that that just had boiler terms from contracts? There certainly are those pages. It's the process of going through and separating that out that is the problem.
So in effect, every single one of those PDFs, every single one of those folders that you're going to presents an insuperable obstacle because you can't say, well, yeah, these 100, no, these are, and again, if all the formats are different, then I guess I accept that it's not as though it's just one standard search.
It is not. And I've thought about what happens if this ruling is against the company. Like, my job is to figure out what are we doing next. Like, I honestly don't know. I guess what we're going to do is we're going to go try to hire an outside firm and see if they can work their way through the information. It will not be ready on the first day of filing. It will take some considerable time. It'll be available some point during the proceeding. And it will not be, we will not feel comfortable that it has a level of accuracy. And so I think fundamentally, that's the only path we would have, and that's what we would do. But it would not be something that could be reliable in terms of the outcome. And again, that's why we're trying to bend over backwards and say, all it takes is to identify the projects. If we can have a project number, we can redact all the information attached to that project number. And so that's all it takes, is a little coordination on that point.
Okay, thank you for your answers. Thank you, Mr. Chair.
So I have two unrelated, but everything's sort of related questions, but you just triggered a thought with me, Attorney Kimball, and that is, like, is there any way to use identifiers to, I don't know how to word this, but like to sort of keep things, to mask things while unmasking them at the same time? In other words, some sort of encrypted key to certain kinds of information so that people would have access to the information, but there'd be some level of security. Have anybody talk about that?
So I think is this what you're thinking of? We did talk to IT about this to find out, like, what could we do here? IT says if we work with the native Word documents, there's a way of locking the Word document so that only people with the unlock key, which could be EOE, OCC, could unlock it. But again, that doesn't give us any granularity. It's like the document as a whole.
I'm thinking more in terms of particular types of information, as a way to, like, in other words, like we have to do this sometimes with survey data, right? We're trying to not reveal identities while still having the whole picture. So this is more of a comment at this point, okay? So just that I think we're all struggling with the same thing. And actually, I want to talk to Attorney Tisler about your point. You said you have a non-disclosure agreement process. Obviously, that's something you've already used in the past. Does that non-disclosure agreement now include use of AI?
So the last time I dealt with one of those was for the Yankee Gas rate case, and I do not believe we considered AI at that juncture.
Okay, because I think what's starting to emerge in the publishing and copyright world is that once a document is uploaded to AI, that AI vendor has that information and is using that information in machine learning processes. So whether or not it's been approved by a regulator, and so it's the world we are all in right now. And so I do agree. I think technology is far outpacing public policy or our ability even sometimes to imagine all the things that we need to imagine as far as data security goes. But I think this is something both public agencies and private companies have to give a lot more thought to be protective of everyone. And I do appreciate your comment too, Attorney Kimball, about the vendors who are commercializing this information. Thank you.
I just wanted to say, back to my comment about what we would do, what we'd have to consider if we were FOIA'd. I saw, Attorney Kimball, your understandable natural reaction to me saying we just handed it over. I didn't mean to be flippant on that, and I'm not. I also, to be really clear, I was in no way suggesting that if we had redacted copies that we'd nonetheless just hand over the unredacted copies. I just, but I think I was just saying that as a way to illustrate, like, I'm still just not sure, and I won't ask for like a legal analysis of this now, but it makes me nervous. Like, I think if we, and I totally agree, Attorney Pace, we are absolutely talking about hypotheticals. I also am not aware of a circumstance where Pure has been FOIA'd to ask for a document that's under protective order. But it does make me nervous, just the notion of if we got a FOIA request and we didn't, we proceeded as the company's recommending, and we found ourselves before the Freedom of Information Commission. It is us and not Eversource that's answerable to our adherence and compliance with the laws. And I'm just not sure. Like, I'm just saying again, like, I'm just not sure I'm comfortable. I'm just not sure how that works. I don't know that we can stand there and say, well, we worked with Eversource and they provided these redactions. They're nonetheless, they would be our redactions in the eyes of the commission.
Chairman Will, do you think, and you raise a very valid concern, and so one of our goals here is to help respond to your questions so you can deliberate and decide what you're comfortable with. What I'd like you to please think about would be, in both situations, the agency has to rely upon Eversource to do redactions. In the first instance, if you grant the request from OCC and EOE and AG, we'd be ordered to have Eversource redact the information using our judgment as to what should be protected. In the second scenario that we've offered, which would be if you in fact do receive a request from a member of the public who wants the information to be disclosed to them, we've said we will step in at that point and do it very promptly and hand that over to you. So we think in both cases, the agency has to rely upon Eversource as the redactor to do the work. We're not asking Pure to take on that responsibility.
Sure. Go ahead, Consumer Counsel Coleman.
Thank you. Reflecting on the latest round of comments from the company, what I'm hearing is a lot of concern about timing and burden on the company in terms of making the redactions. And I'd just like to point us back to the point that other stakeholders had made, that Eversource has had 9 years to prepare this case. Why is it now, less than, a month before they're seeking to file, that these issues are being worked out with vendors and, the feasibility of that? On the other end, if when we get to number 4 on the list, Eversource is asking us to consider reducing the amount of time we have to review their filing by a month in order to make rates effective within the time frame of the statute. It seems that we could solve both problems by Eversource filing when they're ready, August 1st, and then having the full statutory timeframe to review without depriving all of the parties of the opportunity to fully vet the application. That would give additional time for Eversource to redact, would solve the problem on the rate year start, and ensure the transparency that the public deserves regarding this important case.
I'd like to respond to that. And so I think in all due respect, there's an incorrect assumption that's made by the Consumer Counsel in trying to summarize the points we've offered today. What the Consumer Counsel just said was she interprets our position to be it's burdensome and unreasonable. That is true, but that's not the principal argument we've offered for your consideration. What we've said is in prior dockets, Ms. Dixon has identified those prior dockets. You've agreed with the position we've taken for the reasons we've mentioned. You've also agreed that we've met the requirements of an exemption to freedom of information based on the type of information being offered and based on what those exceptions are in General Statute 1-2110B5 as to the invoices and to B19 and B20 as it relates to critical information about our infrastructure projects. We've also pointed out, and no one's refuted this with a citation to a case, that nothing in the Freedom of Information Act directs an executive branch agency to order us to provide redactions where I would submit in this case, we've demonstrated the documents are exempt from public disclosure. So this is not just a matter of us saying it's burdensome or difficult. We actually have the law supporting us that this information meets the requirements and therefore is exempt. So I just want to make sure that our position receives all of its consideration, not just that characterization of what we're relying upon. Thank you.
If I may just briefly, and I think, and I appreciate Attorney Kimball's response to Commissioner Cheeseman, and I think that's really my concern, right? I think, you know, particularly in storm invoices, there's going to be dozens and dozens and dozens of timesheets. There's nothing on those timesheets that is protected or confidential. And so I think that is the critical piece of concern. There is no FOIA exemption, right? Like, or excuse me, there is no, they're just not confidential. So they're grouped into this whole thing, but it's not confidential. So I guess what I'm saying is, you know, if someone asks, true, if something is protected, right? Like, you know, if something is confidential, yes, then it is confidential and it would require appropriate redactions. I guess I don't want to get too far into it, but the bottom line is there's going to be not dozens, hundreds, probably thousands of pages that are entirely non-confidential materials that will be filed in a bulk filing and I don't think those deserve any confidential treatment whatsoever. And I think that is part of, again, I know we've discussed this, but that's really the critical piece of information from my perspective. Thank you.
This goes to Commissioner Cheeseman's question. If we're not talking about project documentation, I think when I answered you about when your question, could there be subsections, the project documentation is very problematic because it has two things going on. It has commercial terms and it also has critical energy infrastructure. However, the invoices, the timesheets, we absolutely can provide to the record unredacted. I mean, yes, they're not confidential. So for the invoice, we can parse out for the storm invoices, some of that information. Yes.
I just want to add a sort of a comment. I wonder if and I'm not making a statement about Eversource it's kind of applicable to motion practice at Pura generally, and it's not even a criticism, but I've noticed that motions for protective order are somewhat rote and somewhat like there's kind of a standardized format, and there's maybe a paragraph just saying like there's this sort of stuff in here and here's the applicable FOIA exemption. I wonder if it might help everyone to sort of navigate this process if the motions themselves sort of were more descriptive of like what exactly is in this document and the specific rationale that the company's seeking and the barriers the company faces in redacting them. I think I'm just throwing out there, I wonder if that could kind of facilitate these conversations moving forward.
I had the same thought earlier when we were discussing that. We certainly will take that burden to be more specific about what it is in the documents. I have noticed, like, we have gone through processes before in front of Pura where we've had to ask for reconsiderations on motions for protective order, where we've had more reasons as to why it would be protected than in our original motion. And why didn't we have those reasons in the original motion? It would have saved some trouble. So I definitely think that's a takeaway from today, is we can certainly be much more descriptive and we can endeavor to do that. The burden is on us for that, yes.
Okay, I think we all understand where everyone is coming from on this issue. So if and unless anyone else has anything to say about the redactions, we can move on to the rate year issue. I did want to just sort of tee this one up, saying, this one kind of was raised by, Pura raised this, and this wasn't, this, as you may have noticed, has been an issue that we've kind of encountered in various forums at a couple different dockets. It's just sort of, it's a problem, frankly, we're just trying to nip in the bud on a moving forward basis, and there have been specific circumstances where we're sort of like faced with this issue, and it was we kind of just had to figure out solutions similar to like a 11-year reconciliation period. We'd rather not, though. Like, I think ideally it would be great if we could get to a place where the final decision is issued. That's the point at which the company sees the authorized revenue requirement. Then our standard practice is to ask the company to submit as compliant at some point after that proposed tariffs. We do actually look at those tariffs to make sure they make sense. And at some point, what would make sense in a perfect world is at some point after we'd say, okay, great, time to implement those tariffs. Please proceed. Having said all that, I recognize that, because of monthly billing, like, it doesn't necessarily need to be, there's no practical, harm necessarily in some amount of sort of lag built into their, as long as like the bills that are actually issued to customers in the billing period reflect the rates that Pura has approved. I think that's all we're trying to get to. And I think, it's helpful in this circumstance, which is different than some other circumstances where at least the rate year is after the effective date of the final decision, which is helpful for us as a starting point. So I just kind of wanted to throw that out there as just a level set for sort of where we were coming from on this. But I'll do the same thing and go around to the parties and ask if they have additional thoughts. So OCC, did you have anything you wanted to add on the rate year issue?
Exactly. I think we might be a little confused on what exactly the issue is that you're trying to solve. We definitely agree. I think Mr. O'Brien can speak to it, but that the rate should start on the first of the month. So maybe there's a discussion we could have here about if we understood, are you trying to build in more time between the date of the order and the rate year, or what is it that your concern is? Because we've given it a lot of thought. There's different models out there in different states that I work in and that the company works in. But so I'm not quite sure we understand what the concern is exactly.
Yeah, I guess the question is, there might not be an issue here, because the question is, our statutory deadline is June 29th. The proposed effective date is July 1st, which is pretty close to the the issuance of the final decision. So presumably the compliance filing for the tariffs would the due date of that would be some point probably after July 1st, maybe the July 6th or something, just pulling off the top of my head. But if at the end of that whole process, there are no customers are still getting bills that reflect the authorized rates, it might not be an issue. I guess I'm just throwing out there. Maybe I was a little confused by, I think, the next slide where the company is sort of offering up other solutions, including like the 11-month rate year. Yeah, thank you. This one. I don't know. I guess my question is is it the company's view that these solutions are even necessary, given that the rate year is effective after the issuance of the final decision, and maybe there wouldn't actually be any difference in terms of the billing cycle effect?
Yeah, so just to talk through, I think maybe the process a little bit once that final order is issued. So obviously, as soon as we get that, it's obviously a very voluminous document. I think the Yankee one was around 200+ pages. So the company's immediate reaction is to digest that as quickly as we can and take all of those final decisions and run that through all of our revenue requirement and standard filing requirement schedules to come up with what is the final revenue requirement. And I know that'll be outlined in the final order as well, but we have to go through that in our own schedules to break that down. And so typically, and Mr. Murray can nudge me if I get this wrong, but I think typically on average, we see about typically 3 days, 3 to 4 days to pull that together. And really the next step is, and that's just assuming, there aren't, not substantial changes, but just working that through all the different models. But then the next step is giving that to our rates team, and Mr. Davis can certainly come to the microphone where I get this wrong, but having Mr. Davis and his team break that down into the actual rates model. And again, it's a very complex process for breaking down all those different rate components to all the different individual rates that we have and we plan to propose in this proceeding as well. And so assuming that there aren't substantial changes to that rate model, there we would expect, again, around 3 days to break that down. And then at that point, we are obviously preparing, as you mentioned, Chairman, the compliance filing, which I'm tracking the date as well, just like a July 6th as an example. Somewhere in that time period, we would be working to make that compliance filing with the authority and provide it for your review. And at the same time, from a billing perspective, and we have Ms. Kane here, who can also provide some highlights on that as well, the company, once those rates are identified, are including that in our systems and ensuring that, we're going through our standard process for any filing that we would go through to ensure that we're testing those bills, testing those rates before they actually go into implementation, which is again around a 3-day window or so. So in totality, give or take 9 to 10 days, the company obviously typically in these types of situations is working nights and weekends to work through that as quickly as we can. So I think, one thing that has come up in the past is the idea of a potential bill hold, but obviously would just like to highlight with any sort of consideration there, that's really available in very short time periods. And the reason is obviously each customer is assigned a particular billing cycle, having a longer lag or time period between when they are invoiced can obviously disturb that. And obviously when you're coupling that with any sort of rate change, that can lead to, as much as we can communicate it, a difficult customer experience. And also just from an IT perspective, having any sort of long bill hold build up could also, is challenging to then process that each and every night to get not only the batches that are then in effect once we relieve that bill hold, but also to get those previous bill batches out to customers as quickly as we can as well. So I think from a timing perspective, we were obviously, I think, Chairman, like tracking in terms of the dates that you referenced. And certainly, I think Consumer Counsel mentioned, we certainly are not trying to dial back a month or anything like that. I think what we were trying to articulate here in the essence of, I think what we just did a few months back in the storms process is, the 350-day requirement on a July 14th filing would take us to June 29th, but certainly the company could look at certain time periods from a briefing schedule perspective or something to potentially build in some additional time to accommodate that 9 to 10-day process that we outlined. It's certainly something that we'd be willing to look at. And the other options, Chairman, as we just indicated, those were just things we wanted to propose just to highlight if we felt or if the authority felt it was needed. There are other things that we certainly could consider. And obviously option 1B, just having gone through that from a Yankee Gas perspective for the rate case issued back in November, that was obviously something that we had deployed there. So just wanted to provide those options overall. And I open it up to my colleagues if there's anything else to add.
I think what we perceive to be the issue is if PURA has 350 days and it takes to the last Wednesday of that period to issue the final decision, which is the typical practice, that leaves some number of days to the end of the month, to the first of the next month. And if we're trying to start rates on the first of the month, that most likely is not going to leave enough time to run through all the processes that have to happen, which means that you're running into the next month and then you have to have some process like revenue decoupling to get you back to the first of the month. And I think what we're saying is if we want to start on the first of the month, it could be the first of the next month. And that would give time for all these processes to run and for PURA to have time to look at the compliance filing. And the other states that we operate in, they do take more time with the compliance filing. And it works just exactly like this, where they issue the rates and the rates are effective, but they're not implemented till 30 days later. And these processes run. So if we're all we thought you might be trying to do is to get to more standardization on how that is working. I'm not sure it changes the rate year. The rate year is always going to be the first of the month after the final decision. It's more about when those rates can go into effect. And if we're trying to work with the first of the month, which we agree with, it's better from a billing perspective and for a lot of reasons, then we just need to have a plan for how we're going to deal with those days between the date that the rates are effective and the date when they're implemented. And maybe we misunderstood what the question was, but we thought it was a good question if you're looking for a standardized process.
I might be one of the people who's been a little guilty of overthinking this.
I don't know if that's possible.
Well, and I assume you're billing all the time, right? You send out bills every day. And so we're on a learning curve on this topic, and so we've had conversations with other in other cases. So, do you pre-test a change? Would you be pre-testing, in the weeks preceding the start of the rate year?
I'll turn that over to our VP, Jess Kane.
Thank you. Can you hear me okay?
Yeah.
Okay, great. Thank you for that question. And what I will start with so Jess Kane, Vice President of Customer Operations and Assistance Programs across our 3 states, is yes, we do testing. And one of the beautiful things about Connecticut is you give a draft decision. That's very attractive. It usually gives us a great insight into, are we building the right thing already? When you just change prices, that alone takes about 3 to 4 calendar days. So we work weekends regularly for that. What happens in a rate case is usually it's more complex, some new rate component, break this line item out, or like we just had happen in Connecticut where we were like, hey, we can do a single line item, and that's relatively easy. But if you break something apart, it's way more difficult. So what our teams do is as soon as the rates team says, here are all the prices, we enter them in all the different combinations, including some of the crazy but beautiful stuff that Connecticut has implemented in recent years, like the supplier pricing protection stuff for July 1, where if for low-income customers, where they drop to the lower of, if a supplier has a higher rate than standard service, then they're dropped to standard service. And, some of the other for matching payment program. The matching payment program, which is an arrears forgiveness program for low-income customers, it needs that price in order to calculate what the customer's monthly required payment amounts are going to be. So there's like a lot of complexity in the things we have to regression test. And it got way more complex in the last 10 years with solar as well. So when we bill, it's not just billing anymore. We're throwing out payments, and the solar allocatees are waiting for those payments. So what we do is we'll load in the rates in a test region. We run it through, but once you enter them, you have to run a mock billing. And every night in real life, we run, say, Monday through Friday nights. We start our batch nightly processing around 5 p.m. It runs till around 5 in the morning, and it runs payments and billing, service orders. It'll go through collections, and then I think that's probably the final jobs in the morning. So we have to test to make sure none of that breaks. So then we need to run it through in a test region to make sure it bills okay, and then we run it through in production. In production, we run it and we put a pause on delivering the bills. So about half our customers get e-bills, and the other half get printed bills. We pause, and we've got people up all the night before, checking all the different super weird combinations of bill types and charge types and supplier combinations we have, so that we don't miss a segment who has a weird, Connecticut even has some time varying rates on a few hundred residential customers. Like that stuff is weird and complicated to test. So that is what we do each time. And we did think about the 4th of July weekend next year for employees, like, okay, what could be, but so yes, we do the pre-planning and pre-design testing, but it also depends on the complexity, because the complexity of what the final decision could be, or the draft decision, it might require design, build, test of some totally new things. And that's not a quick thing. For example, the low-income discount rate, right? That would, that's like, that we're on track to implement in November. And that wasn't the question, so I'm going to defer back to Brendan.
And just on the topic of pre-testing as well, obviously, one thing to just think through and consider as well is any changes between the draft and final decision that are modified. Obviously, we have to go through that same exact process again to break that down into the individual schedules. We would obviously be doing that at the time of the draft decision to run that through our modeling to begin that process. But then any subsequent changes after that point, we would have to go through and break that down as well. And just obviously to ensure that we're maintaining our controls, any change that Ms. Kane mentioned, we would have to run through the exact same control procedures and processes to ensure that, any pricing change, we're administering that same rigorous process to ensure you're ultimately issuing bills accurately when they go out.
May I add one more thing? Holding bills. So I had to swallow hard on that. Holding bills for like a day or two, palatable, but that means that nightly process, it takes like 12 hours a night, you're double stacking it. So operationally, you still need to run as many customers through the pipe, you just now have less time to do it. When you get to a certain point, it's the systems that you can't back up that many cycles of billing. And that also does become disruptive. I think Chairman Wheel, you mentioned as well, from a customer disruption, timely and accurate bills, we have to defend that. Auto pay customers getting, twice. So we're not aiming to delay ever more than a few days for customers. Thank you.
Okay, thank you for all that information. So it sounds like you know a lot about what you're supposed to do. And you've also got a lot of months, 350 days plus, to think about it. So it sounds like your position is well prepared. I mean, one theory Pura could adopt is that once the authority has made a decision and we've indicated the first day on which rates will be authorized, it's from then on, it's really up to you to get that implemented. In other words, rather than implement some alternative rate model. In other words, it's sort of up to you to get that in place, and that could, in theory, involve some delayed implementation. Again, that first batch of customers, might not be ready, and then it's kind of up to you. And I don't know, I actually don't know, Chairman, like what our authority would be there to approve a hold and then a somewhat larger bill. But in some ways, I mean, that's where, our lag ends and yours begins in terms of implementing the new rates. In other words, you've been authorized, you've been told what you can charge. And so you've got to get that in place. And I don't underestimate the task, I know, but that's just kind of that's something I want to think about. Like what is our obligation after we've made a decision and we've told you when you can change the rates? What happens then is just something we need to think about, if that makes any sense.
If I could just respond to that, I think
Yeah.
the problem becomes is legally, once you've approved a rate, like that is the legal rate. And so when you allow the company to get that rate through the revenue decoupling, there's no rule on where you get it, right? You're just allowed to get it. So that using a different rate mechanism is within that approval. But I don't think, requiring the company to charge the lower rate that it's just gotten approved for I don't think that would be like a lower.
And that's not what I'm suggesting. I'm really suggesting it's up to you to bill your customers in a timely way to reflect the new rates that you've been authorized to charge. In other words, we've handed it back to you to
But I think
to
that
implement.
goes back, then you're holding bills. You would have to hold bills. And that's why we're trying to explain to you, like, there isn't a bill hold that can be physically done for the time period that's needed to run all the things that have to be done, including getting the compliance filing into Pura. So that's kind of the conundrum we have, is that we would have a legal rate that has to be charged for every ounce of consumption after that. And so how is that getting charged? And if it can't get charged on the bill, you have to hold the bill until you can get that rate on the bill, but you're talking about holding it for like 3 weeks, which is not possible, given everything. So I think that creates like a legal conundrum, that you've approved a rate that cannot be implemented because of the challenges of the process.
So you're saying it couldn't be implemented with the rate shock problem that you described earlier? Because, I thought that's what you're saying, like there'd be a hold, but the bill would still reflect the change. You're saying you couldn't calculate a bill.
I think from a calculation perspective, we could calculate it. I think it's, and I'll let Ms. Kane chime in, it's the process of building up that hold. We bill on a cycle basis. I think it's 1 to 20 or 22 cycles. Each one of those are typically aligned, like cycle 1 customer bills on the first, second day of the month, and so on and so forth throughout. I think it's the process of holding that for just looking at the calendar. If the decision date were to be on the 350th day of June 29th, talking through that process, just considering 9 days, 9 to 10 days, that kind of brings us to the completion of that process on or around July 8th, 9th, 10th. And that's assuming nights and weekends to work through that process to get to that effective date. And I would imagine that's quite a few days of bill holds. And I'll let Ms. Kane take it away from the process and the issues that can charge. It's not necessarily, I think, a calculation perspective on terms of the overall bill, but the process of administering that and moving that forward.
Yep. And I might not be understanding all of the question. So you mean like if we use that time, meaning the Pura would want us to hold bills for half the month for customers, if that's our, because that would be bad. And I can go through some of the reasons. I'll just use what we talked through in Massachusetts and why they agreed to do something different. I just grabbed our same filing there from 6 years ago when the same thing came up. Because it's every, utility, maybe not the little water companies, but but we're going to bill on the rates we're supposed to be billing on. But so the delay in to explain why their customers are not receiving the bills, that's not a good, that would not be a good experience for customers who have complex bills like Amtrak and ESPN. They've got some complex big bills and they really need to see it on a monthly basis. Municipalities have their budget years, so if they're delayed by 2 weeks, that ends up being an issue for the amount of their bills and the delay in their sync. Again, customers on auto pay, credit notifications. If you're not processing bills, we can still process payments, but the notifications get to be a little inconsistent or just like standalone, right? If you're not also billing, budget billing customers, and budget billing is the brain that uses your average monthly usage at today's prices. So for a period of time, nobody would be able to sign up for budget billing or the matching payment program. So for that, say it's 2-week period, no low-income customers could sign up for the matching payment program. That's not what we have advocated for in recent years or ever. Customers, I think then we've got the net metering credits, like for allocation. So there's some, like if that's we're laying out in good faith, like here are the options. And I wouldn't advocate for this, but could we in the next year figure something out? I just don't think that's what Connecticut, we've done in good faith efforts many good things for our customers in recent years. That doesn't feel like it would be a good one to do. But
Consumer Counsel.
Thank you. And thanks to Ms. Kane for all of the examples. I am in agreement on the practical, and the legal challenges as far as, once you have a rate set, it's got to be done quickly. And that yet there's processing that needs to happen. I do think we're premising this whole conversation on an assumption that July 14th is the only date that Eversource can file its rate case. So I'd like to step back for a minute because it seems like there could be option 3 and 4 to address this in the best interest of customers to avoid these challenges that Ms. Kane has laid out. Eversource can either file before July 14th and allow us the ability, or allow Pura the ability to extend the timeline of the rate case, which after so many years of being out would, in all transparency, be our ideal scenario. Or Eversource could wait and get us closer to the natural transition of an August 1st rate year. So there are options other than these that I think would benefit thinking through.
Just as a question, so your preference would be for the company to file earlier?
If the company filed within, sometime in July, that would trigger the statutory flexibility for Pura to determine that an additional up to 90 days, as referenced by your colleagues, could be added to adjust. So yes, it would be
So
our preference.
in both of those options, what you're saying is the 350 days is triggered by the filing unless the company waives it.
Correct.
So either one of those options means the company is waiving some period of time.
I don't believe the first is a waiver. It's a statutory authorization for Pura to extend the timeline of the rate case due to multiple rate cases happening at the same time. So I wouldn't consider that a company waiver.
Okay, so I'm sorry. So thank you for that. So you're saying if they did file earlier, then it would be up to Pura to add up to 3 months.
Right, and it could account for this challenge of when
Yeah.
the final rate year, or the rate year begins with the billing challenges to be
Okay.
able to trigger.
So, Mr. O'Brien, is the company willing to roll the dice on up to 90 days at the end?
So no, just for a couple of reasons. I think just to start, as I highlighted, and I believe we highlighted back in the March hearing process for the RAM, the company's original plan was to file the rate case or the notice of intent in early May, file the rate case in early June, and building in some of this time for the ideal compliance timeline. Obviously, due to the statutory changes that occurred last summer, we needed to adjust and accommodate for that. And really, the reason is we need some level of certainty on when those rates are going to take effect. And in order for us to operate the business, it's very challenging to introduce potentially up to a 3-month delay in a full 90 days for when those rates would actually come into effect. And just to comment too, in terms of the importance of some of these dates, our revenue requirement that we've calculated that's outlined in the notice of intent and will ultimately be included in the company's filing is based on a particular rate year. So for this individual filing with an effective date of July 1st of 2027, the rate year runs from July 1st of 2027 to June 30th of 2028. So the challenge to be able to make some of these modifications is with that extension of the ultimate effective date of rates, you're really adjusting and changing the rate year. And I don't think where we are now, a few weeks from that July 14th date, there is a possibility to really make changes. We're well along in terms of not only our revenue requirement calculation, but all the subsequent testimony and information that's included in that. And so making those adjustments really kind of resets the company to the beginning of the process to go back and establish the revenue requirement in line with the associated rate year.
Can I just jump in on that point? This is kind of circling back to like the way I was thinking about this to begin with. I don't say this to be combative, and it's really not even the context of this case, which I realize has its own sensitive history. But I was surprised somewhat recently to find, I don't think that the law, either the statute or our regulations anywhere, says that the company gets to choose the rate year, or it doesn't say anything about it actually. Like there's a statutory deadline for the issuance of the final decision. But I've seen rate cases where the rate year is like, it's kind of up for grabs. Like the company just sort of seems to choose like what rate year it would like. And then everyone just sort of has to follow along with that. And I'm not pushing back on, but I'm thinking about this systemically from like a best case scenario perspective, even outside the corners of this case. It seems to me that for all the reasons we've just discussed about how hard it is to rush through this and make sure rates work, an easy solution would just be to say, well, we issue a final decision, but we're approving rates effective a month after that. I'm just saying a month arbitrarily, but like effective for some date after the issuance of the final decision. And I agree, Mr. O'Brien, in order to do that, you'd have to start there. Like you'd have to have the SFRs anticipating that rate period ahead of time. I'm not asking the company to do anything here. I'm just sort of trying to level set. Like that's kind of the problem I'm trying to, it would be, that seems like an ideal solution. And frankly, like this comes up in the RAM, right? Like we see there's kind of a faster way of doing the RAM, but in the RAM, we issue a final decision like a week or so before either May 1st or September 1st. Sometimes we do it too early and the company's like, whoa, we need more time to set the rates. And it's funny to me that like, that's a problem in the RAM, but not in a rate case. In the rate case, it's like, oh, well, it's fine. We'll just retroactively correct it back to the effective date. So I'm not trying to argue or anything. I'm just trying to say like, that's the way I view this is, I agree, like we need to have certainty and the rate year everyone needs to be like kind of looking at the same rate year. I don't know that the solution is necessarily that we need more time to do the rate case. I think it's just sort of, maybe it's like that gap between the issuance of the final decision and the effective date of rates. Seems to me like it would be the reasonable solution would be for there's just more time there for everyone to kind of work all this stuff out.
I think that's dead on. But I think the statute does say it's 350 days. Rates have to become effective 350 days from the filing.
I think, and again, I'm not being argumentative. I think I was surprised. I like had that in my head too, but it's actually, the statute is the issuance of the final decision. It's silent actually as to the rates themselves, which I also.
But rates become effective upon the final decision.
But I don't know that that standard exists. And if it did, then we'd have a problem with the RAM too, right? Because that's not the standard there. The final decision is issued in the RAM like a week, 10 days before the actual effective date of rates.
Which is a reconciling mechanism, right? It's not a base rate mechanism. So we just have to think about that. I mean, I think that one issue with the Connecticut statute is that in Massachusetts, New Hampshire, Rhode Island, the statute is just a little more prescriptive. And what it allows for in Massachusetts, the way we do it in Massachusetts, is you file, the rates effective is determined by a tariff. You file a tariff. The tariff says, I'm going to put rates into an effect 10 months. So the statute allows 10 months in Massachusetts. So you file a tariff with an effective date of 10 months from now, so that the department's order has to be issued before that date. The first thing they do is they suspend the tariffs. They have power under the statute to suspend those tariffs. And then they take those, and their statutory suspension time is 10 months. So they suspend the tariffs for 10 months, they issue an order by that date, and then the rates are effective the date that they issue their order. Otherwise, those tariffs go into effect. So it's very crisp and clear. And I agree with you, like the Connecticut statute definitely is not that clear. And then it has the complication of it allows the company to bond and put rates into effect, which is like an interim rate, which New Hampshire has, like a temporary rate. So there are some grays here, but I think that we will run into a problem if we think that we're going to start extending the 350 days by utilizing, kind of like workarounds to the statute. That's all I would say.
Could I add one more point? And you raised a very good question, Commissioner Wheel. So when I looked at the language while you were speaking in 1619 subsection A, and I'll just read it so everybody has it in their minds. The authority shall issue a final decision on each electric distribution or gas company rate filing not later than 350 days after the effective date of the proposed amendment. And your point was it says a final decision. It doesn't say a rate amendment. One way maybe to get people more comfortable with the concept we talked about is if we go down to subsection B, it says if the authority has not made its finding respecting an amendment of any electric distribution company or gas company rate within 350 days, then it goes on to say we can then, upon posting appropriate surety or a bond, have rates go into effect subject to your final decision. So that both those sentences read together, in our view, demonstrate that what comes out on day 350 is not only a decision, but it is a decision on the rate amendment proposed by the electric or gas company. So we'd like you to please consider that if that helps the agency get more comfortable with what Attorney Kimball was proposing. Thank you.
Yeah, again, I'm really not trying to be combative, but like, that doesn't even align with your proposal here, though, because you're saying you have a 3-day gap between final decision and effective date. So, I mean, I'm just pointing out, this is really like a problem for the legislature or for
Yeah.
our regs or something. Like, it's not even an appropriate conversation to have here, because I recognize you've been spending months putting your rate application together.
Well, and we want to help, like, we want to find a way, like, that's why we tried really hard to find a way to give flexibility here, because that's clearly would be helpful. And we even looked at this process with the bond, but unfortunately, what we feel like with the bond is it would take you right back to that 351st day, where like we can agree for some time, like a few days, like that's fine, we can all agree to that. And so it's kind of an imperfect statute, and it does take some collaboration. So that's why we offered up these ideas as ways that we could try to, we weren't completely sure what the question was, but if we're looking for some time and flexibility to make sure that those rates are correct, that they're putting into effect, everybody wants the correct rates, and especially Pura would want that. So if we're looking for some more time, we just tried to give ideas
Thanks.
based on that.
I appreciate that. And really, and at least to the extent the question was coming from me, it really wasn't an attempt to see like, how much further can we push this out? It was more about, kind of taking this opportunity before we even have an application of like, hey, maybe we could talk about this. But I appreciate all the input. I'm sorry.
Thank you, Mr. Chairman. And so I am familiar with the model where you file tariffs and then you suspend and start process. And it would be pretty rare if that same tariff ends up being the one that's approved though, right? So it's just it's just sort of the procedural model that's used. So I guess I just want, I'm still learning, and so I'm interested from hearing from both of you on whether you think that upon the decision, are we mandating that you change rates, or are we allowing you to change rates? Is it permissive or is it mandatory?
Maybe this is splitting hairs, but I don't actually think it's either one. I think a utility is not allowed to charge rates that are not approved by the commission. I start there. Once you've approved new rates, those are the only rates they can charge. That's the product of the deliberation, and that piece of paper that you issue, those are the authorized rates that we're working with. And I've had lots of different clients at different times want to do different things, and I've always advised them, you cannot charge any rate that isn't sanctioned by an order of the commission. So now we're talking about this timeline between that piece of paper and when rates are really into effect. And I think and if it's a short time, if we're talking 3 or 4 days, potentially bills can be held, potentially things can be done. Once we get past that 3 or 4 days, something else has to happen. And I think that's all what we're trying to address. I don't think you're either permitting or allowing, you're deeming a rate to be the lawful rate. And utilities cannot do anything that they're not except for what they're sanctioned to do on rates. That's just how I look at it.
So technically, under the law, you don't view any grace period at all. It's instantaneous and then.
It would be.
So then it's a matter of when you get those accurate bills into the hands of customers and what you do to mitigate the impact of that potentially.
Correct. And that's why in other states, we've been able to build in one way or another, this like a 30-day period. Now, Massachusetts only has a 10-month suspension period. So I will tell you that sometimes we file just exactly to the question asked earlier, where the rate year is after, it might, for our electric company there, we file where we get an order in 10 months, but we start rates on January 1. That's how it works in Massachusetts. So we give up, just like Consumer Council is suggesting, but that's that's a 10-month rate cycle. Here, I think I'm just talking out loud. They know I do that. But here, the problem is the law gave 350 days to Pura. Pura took the maximum amount of time, a year. If you're trying to build in another 30 days without, without changing rates, that's now 13 months. That is like a long time. That creates a lot of issues that Mr. O'Brien could probably address. Financially, it gets you off track. You can't, the financial cycles are off track until the next rate case. Like 13 months is too long.
But legally, that sounds a little bit like a distinction without a difference, because 10 months or 12 months, you're saying you accept a 30-day grace period in the 10-month state,
Yes,
but you don't accept it here.
correct. Because it's disruptive to the business and how the business can operate between rate cases, to be off of a calendar year.
It's like, oh, okay, to be off.
Yes.
That's due to the calendar year aspect? Okay,
I mean, there's more business things that a witness could speak to if you're interested. I don't
Like
want to drag this.
6 months would be even better, right? I mean, like then,
6 months isn't enough time for anybody to do a rate case
Right,
these days. also.
exactly. You kind of made my point.
Yes, yeah.
We, as has been highlighted here, this is a big case that is playing a lot of catch up. So there's a lot of work to be done. And everyone owes this obligation to the public to do it well and do it right,
Yes, correct.
to the best of our ability.
With that,
So,
100%.
I mean, I think the calendar is what it is, but I will stop there, Mr. Chairman. I believe somebody at that table might have had a comment.
No, I'll save it. Sorry. Thanks.
I don't think I have anything to add. Thank you.
Okay. I apologize for forcing us into that conversation. That was my fault and Commissioner Beecher's fault. But thank you. I appreciate everyone's input. I really wanted to quickly raise just one thing that isn't actually on the agenda. Which is to introduce Jay Goodman of of Couch White representing CIEC.
Thanks. Just wanted to comment very briefly. With respect to the timing issue we've just been discussing, I don't know. We don't have a preferred solution or recommendation as to what should be done, but I would like to advocate against a couple of the options presented here. One, the 1A of essentially approving rate compression, allowing 12 months of rates to be recovered over an 11-month period. CIC would oppose that in a standard rate case, especially because that just increases the impact of what is potentially a material rate increase to customers. So we would, advocate against that. And second, in terms of the option of the commission rendering a decision sooner than not using all the amount of time necessary. I don't know how much time ultimately might be needed to work through this, but we do have a concern that the state agencies in particular have as much time as possible to work through what is clearly going to be a huge volume of information, because CIEC doesn't have the resources personnel to do the deep dive into the filing like some of the other parties do. And we really rely on their comprehensive review. So I want to make sure that they have as much time as possible within the schedule. Thank you.
Thank you very much. So if everyone's ready to move on to the last thing I wanted to raise, it's not on the agenda, but I just wanted to kind of point out at this opportunity before the application is actually filed, just to raise for everyone's thoughts moving forward, the issue of public comment hearings. First, I'd be curious for people's input on the number of in-person and virtual public comment hearings that would make sense. And I won't ask for people to respond right this instant unless they feel like it. For this rate case, it's kind of another area where there doesn't seem to be like a standard for PURA, but it's something that we generally work on once the application comes in. Also, the location of the in-person hearings, and the OCC has raised in some other contexts a potential preference for having maybe like some hearings kind of closer to the evidentiary hearing. That's something, so the actual timing of the public comment hearings sort of within the procedural schedule would also be helpful for people to think about, like providing any input on that. And lastly, this week we're trying this out for the first time, but OCC's participation in the hearing, like as a formal part of the hearing, giving a presentation. Those are just sort of things I wanted to put out there for maybe food for thought. Obviously, we'll have time, as everyone I think in this room knows, we get the rate application, and then at some point after that, we tend to issue a procedural schedule. We'll actually probably have a scheduling conference, and maybe this is the appropriate place to have those discussions, but I just sort of want to throw it out there as something to think about. And I think that's all we have on the agenda. So,
Chairman,
the AI issue, which was that where you were going, Attorney Pace?
one other issue also, but let's go to the issue you raised about AI. And if I have permission, I'd just circle back to one issue very briefly with your permission.
Sure. So Commissioner Cheeseman reminds me, we didn't, I think it sounded like the company was, Attorney Pace, you were asking if potentially the various parties could speak to whether they plan to use AI to analyze documents, or was the idea sort of that that's something to be considered in the context of, well, I'll let you.
I think what I can do to comport with due process to allow for feedback from affected parties, one approach we could take if that works for the authority would be we can submit that request in writing in the form of a motion and say it's our proposal that if a party wants to use AI, it'd be under those two conditions. Just let us know you're doing that and answer some questions about the model so we can make sure the right safeguards are in place. That'll give the other parties a chance to comment during the 7-day period, and then you can see the benefit of their feedback, and then you can render your decision as an agency. If that works for the other parties, that works for Eversource.
Does that make sense to EOE? Does that?
Yes, that's a reasonable proposal.
Yes, no issue from EOE.
No issue from AG.
Okay. Relatedly, something that just popped into my head, I just wanted to kind of raise, this may be more OCC's point to raise potentially, but I am aware that last legislative session, there was a change to OCC's enabling statute that brought in language that mirrors PURA's language with respect to its treatment of confidential information. So I just wanted to raise, Attorney Tisler raised the question of the agreements, to the non-disclosure agreements. Thank you. I just wanted to raise, I'm not sure that, I think, having worked there at the time, I think the intent of that statutory change was that those are no longer necessary for OCC, but I'll throw that out for OCC to speak to.
Yes, thank you. We debated whether or not to correct the record on that, but you are correct. Under 16(2)(j), OCC essentially adopted the same statutory blanket protections if we endeavor to review confidential information. We have worked with the company on changing the protocol in other cases that we no longer have to sign an individual NDA, and we operate under the same confidentiality restrictions as the authority, and anticipate we can do that going forward as well, and happy to work with the company to make sure there are no concerns.
Yeah, I'll acknowledge that, we are aware that the two sections in Public Act 25-173 that deal with the issue, and the OCC has approached us on prior dockets, and I hope at least we work with them collaboratively to address their concerns. So thank you for that feedback.
Okay. And Attorney Pace, you have, I think, the last issue.
I will, and I'll promise I'll be brief in light of the time of day. I just want to circle back to, the very contentious issue that the parties talked about, and I appreciate the very spirited debate because I understand the public concern that's at debate, and that's on the issue of redactions. And so I recognize that based on the feedback we heard from the commissioners, this is a very challenging issue for you to have to deliberate on as you leave today's public comment session and today's procedural conference. The issue we'd like you to please consider as you deliberate would be if you conclude, for example, that the invoicing information we provide does not rise to the same level of import as, for example, the critical infrastructure information we seek to protect. And you therefore, for example, order us to produce redacted copies of the vendor invoices. We'd like you to please take into consideration that there's no provision in FOIA nor any court case or agency decision that we've heard that says on day one of when you file the application, you must have a fully redacted copy. And so therefore, we'd like you to please consider as you deliberate, if that is your conclusion, that at least some reasonable period of time be provided to allow for the redaction process to be provided. I would note that we're not going to go to hearings in a week or two after we file. Hearings will come much later in the process, and certainly we can produce those redacted copies in ample time to allow them to be available for the hearing process. I'd also note that as you deliberate, and a comment was made, we've had a number of years to prepare for this case. And as you can hear from the comments offered by my client, Ms. Dixon, we spend a lot of time thinking about the way we organize the case, the way we present the information, and a lot of work is done many, many months in advance of filing it. And I just point out the reliance interest, and that is, it is reasonable for a public service company to look at prior PURA rulings and conclude you'd apply that same treatment going forward. And again, I know I said it 2 times, I'll say it a 3rd time. Ms. Dixon did point out, we're not just raising this for the very first time. You've decided this issue in the Yankee Gas rate case and in the storm cost recovery docket, and you agree with the position we're advocating for. So if you decide to change the position, we ask you to please take into consideration the reliance interest, and if you order redactions, allow for some reasonable time frame to ensure that we can provide it in an orderly fashion. And we don't think, in all due respect, in a 1-year process, getting it a number of weeks or months into the docket is going to cause prejudice to parties preparing for hearings that may occur in the September timeframe. So thank you for the chance to offer those thoughts. And again, I appreciate the arguments offered by the other parties on this. Thank you.
Just add one thing. And they're talking about hearings. We're also talking about interrogatories and discovery. So there's a vast difference in time frame in that right there.
Yeah, and I would just reiterate, for discovery, we've already said that if any party in discovery has a focus on a particular issue, we'll provide the redacted version in response to that particular interrogatory. So I know it's not going to be a perfect solution, but I'm just saying we're trying to work with people to achieve a reasonable compromise. So thank you for the final thoughts on that. Appreciate it.
All right. I think that brings us to the end. So like I said at the beginning, there actually is no motion before us technically. So I think we'll probably just issue correspondence from all 5 commissioners offering direction as to the issues that we've discussed today, if that works for everybody. And we'll get back to everyone via that correspondence. And I guess the next step after this is we'll wait for the application to be filed. And then, as I said before, I'm sure we'll issue some preliminary schedule there, but I imagine our first step is going to be scheduling a conference after the filing of the application. So we'll see everybody back for that. Thank you very much to everybody. Have a good day.